Can I just have one last look at academy number 2 and
yes, certainly.
try to get a slightly more rigorous mission? First of all, can I start by saying I accept that Lord Justice Ryder was not laying down a rule that public revulsion, public confidence in the functioning of the system can never be relevant.
Yeah.
Secondly, if you read the judgment as a whole, it is plain that he is dealing with a situation outside what he describes as the paradigm case of someone coming to the country and committing offences. Instead, he is dealing with a situation of long-term residence, and is at pains to say so. And he is...
Yes, not just long-term residence, but birth in this country.
Yes,
yes.
Well, certainly on academically, on the actual fact of academically.
Yes.
But birth in... And it's in that context that he is, I say, holding that the weight to be attached to confidence in the criminal justice system is slight and is not obviously furthered by deportation. If I can try to just give your lordships the paragraph numbers to make good that thought process. We go to academy number 2. Which is at tab 25. The thought process starts paragraph 33. In a discussion of my submissions, 33, the context of this case, which is submitted, is very different from that being referred to by Lord Wilson, is that the appellant has lived his entire life in the UK. That is materially different from the paradigm foreign criminal who arrives in the UK from another state and then commits crimes.
Yes.
Circumstance where the need for foreign nationals to appreciate the consequence of criminal conduct in terms of expulsion is much more obvious. And then 34, my submission was to what follows from that. We then go to 37. See, the Secretary of State recorded a submission that the appellant's case is not exceptional. And then, importantly, the last 4 lines of the paragraph, there is no fundamental distinction between a foreign criminal who's come to a host state and one who is born here. Public interest in the deportation of a homegrown criminal is not fundamentally different, and the legislation makes no distinction. Accordingly, no error. And then 39, as we've seen already, is my submission to the contrary. So all of that is in the context of distinguishing between the situation of someone who is born in the UK and has lived their life here, and the paradigm case. And then 44, if we jump to that, Secretary of State said, in plain words, is the legislation and the rules says there's nothing to support a distinction being drawn between a foreign criminal who enters this country and offends, the one who is born here and offends. If Parliament or the Secretary of State intended such a distinction to be drawn, it would have been easy to articulate that in the instruments we must apply. I'm not persuaded that this is the case, and in any event, the principles which underpin the legislation and the manner in which the factors that are to be considered in a balance between the public interest in favour of deportation and Article 8 has been extensively analysed in the Supreme Court. So there, according to submission by the Secretary of State, which is similar to the line he's taken on ground one. Our rejoinder is that if you're conducting the argument through 117C6, then you have to build in appropriate appreciation of the fundamental distinction between the paradigm case and this case. And then if we go on paragraph 50, my judgment, there can be no doubt, consistent with Strasbourg jurisprudence, that the Supreme Court has clearly identified that strength of the public interest will be affected by factors in the individual case. Fixable or movable interest, not a fixed interest. Lord Reed provides the example at paragraph 26 of a person who is born in a country as a relevant factor. Find this approach to the weight to be given to the public interest in deportation on the facts of this case, that could lead to a lower weight being attached to the public interest. And then we end up in paragraph 52, as we've seen already.
Yeah.
Now, if we go from that,
But before you leave this, isn't the crunch point 53? Because having said that the upper tribunal's approach was flawed, Lord Justice Ryder goes on to say the exercise of considering the strength of the public interest by assessing the factors in the case has not been undertaken. In particular, the extent to which a foreign criminal who was born in the UK and has lived here all his life must be considered alongside all the other factors that relate to the public interest in deportation before that is balanced against an assessment of the Article 8 factors. For these reasons, ground one of the appeal succeeds. So what he's saying is you can't simply approach the matter that there is no differentiation to be made between the circumstances of the individuals in question. You've got to take into account all the relevant factors.
yes, but then you go to, that puts an emphasis on, an onus on the relevant fact-finding tribunal to say why it's in the public interest for deportation to occur on the facts of this case against this particular background. It plainly hadn't done that in Akinyemi number 2. And recently, that when you read the first tier tribunal decision, other than a statement, deportation is conducive to the public good. Given the nature of the offence, I take into account there's no further reasoning at all about how the public interest argument pans out in the case of someone who was not only born in the UK, but was a British citizen at the time of the commission of the offence, and indeed the court exercise that followed it, conviction and sentencing that followed it. Come back to the theme of the whole morning. What I've properly identified is the public interest in deporting someone who is a UK national at the time of the offence and has lived here all their life. One should be able to go to a tribunal decision and find out what the evaluation of that public interest is. We know with clarity what the Secretary of State thought, because he thought paragraph 6, public interest in deportation, deterring and preventing serious crime generally and by upholding public abhorrence of such offending.
Well, isn't the analysis in paragraph 32? So under the balance sheet, the cons, the factors that weigh in favour of immigration control, that is to say, in favour of deportation being in the public interest. And then the the 2 points that are made are firstly, appellant convicted of murder received a life sentence. Deportation conducive to the public good for those reasons. And then there's the situation that's dealt with in B about his relationship with his wife being formed at the time he's renounced his British citizenship as a citizen of Pakistan.
Yes, but 32A is a conclusion. It's not explaining why it is that the fact that someone has renounced their citizenship after the commission of the offence, in circumstances where he was born in the UK and was a UK national by virtue of that fact, why his deportation is in the public interest. Now, other than the very simple thought that you remove unpleasant murderers, but beyond that, we don't see how the public interest is actually panning out. If we go, my next stop is what Lord Wilson actually said in Shamali, sorry, I'm not feeling like kidding myself. If we can go to, let's have a look at what Lord Wilson actually said. Tab 15, paragraph 70. Of the foot of page 261. Actually, it may be worth picking it up just before paragraph 70. The letter G. Well, at letter G, Lord Wilson records Zulfiqar proceeding to ask if an individual...
So, sorry, which paragraph are we in?
Well, actually in 69, despite my confusing statement, I was going to take you to 70. But halfway through 69, page 261.
We probably need to read from the start of 69,
I'm
don't we?
very happy with that.
So just pausing at the end of 69, he clearly endorses the previous case law, such as DS India,
Yes.
about deterrence. Then 70, which is more on this point. Do you want to read the whole of 70?
Yes, I think yes. It's
Yes, I've actually also read 71 because he refers forward to it.
Yeah. So the public revulsion aspect of the case that survives into Lord Wilson's formulation in paragraph 70 is the maintenance of confidence in the system.
Yes, I read this again over lunch because I wanted to remind myself exactly how it went. What system is he referring to? I mean, I don't quite understand his reformulation in the second half of paragraph 70.
Well, doesn't it relate back to 69, as your Lordship points out? It's the public concern, why in particular do the people of the UK, just below letter E, while their elected representatives, take the unusual step of preempting the Minister's decision whether a deportation was conducive to the public good by making a formal resolution in section 32(4). No doubt they did so primarily because of the strength of their wish to protect themselves from disorder and crime. And then there's the reference to Lord Carr.
Am I right in thinking, again, I just checked this over at lunch, but I wasn't able to have a chance to check it all through, that on careful reading, this is, as it were, a private debate between Lord Carr and Lord Wilson. Lord Carr is critical of what Lord Wilson said in an earlier decision in the Court of Appeal. Lord Wilson accepts that criticism up to a point. But I don't see, neither of their judgments are expressly agreed with by anyone else. And I don't see, although I had a quick look for it, that Lord Reid really focuses on this question of what the nature of the public interest is.
I think that's right, but that just leads me back into Academy number 2, because there we do have a reasoned Court of Appeal judgment, which, fully aware of paragraph 70 of Lord Wilson, says that the public interest factor, maintaining confidence, disquiet at the nature of the offence, or the disquiet at immigrants coming into the country and committing it, doesn't work in the same way, where you have long-term residents in the hands in the...
So is this right? You're making a modest, but on the facts of this case, entirely sufficient, you would say sufficient submission, that public confidence, exactly what one means by that, is a relevant factor generally.
Yes.
And Lord Wilson is not to be read as having disavowed that. But that in this particular type of case, where someone's been present from birth, it has no significant weight.
Yes.
Precisely.
And we'll ask that. I mean, yes, that is a submission. Limited to this type of case. And the way of testing it is the legitimate public revulsion at the commission of an offence by someone who is at the moment of the commission of the offence a UK national. Well, obviously, everyone is revolted by very serious offences of the sort that have been played in this case. But is that relevant to immigration control? But it doesn't undermine the confidence in the way in which the immigration and criminal justice system are working together. It's simply not relevant to it. That may actually be the answer to your Lordship's question about what system are we talking about. We're talking about the relationship between immigration and the criminal justice system. That's the very nature of this line of provisions that we're talking about. So that one needs an answer to the question, what is the public interest in deporting someone at the end of the criminal justice, the workings of the criminal justice machinery, when the remedy of deportation was simply not have been available but for the renunciation of the citizenship, where the offence is committed by a UK national. Now, we don't get an answer to that from the FTT or the upper tribunal decision. And it's a different, even doing it on the basis that we are within the definition of foreign criminal for all the reasons discussed in relation to ground 1. Sorry, I'll keep on going. even aligned to that, and there's a public interest issue which needs developing. Now, I won't take your lordship's to it, but obviously your lordship knows that Lord Carr's views are set out later in the judgment and referred to by Lord Justice Ryder.
But his views are really quite, they go quite far. They really say that public abhorrence is irrelevant in any kind of case, don't they?
They come very close to that. There's a sideline passages that 164, page 287 of the bundle.
I mean, 168, expression of societal revulsion, the third of the factors in OH Serbia, should no longer be seen as a component of the public interest in deportation.
Yeah.
It's not now. And I mean, it is a bit puzzling rereading this, that Lord Wilson appears to accept that paragraph, and yet he goes on to say, but it's still relevant to public confidence, and I don't quite know where we've ended up.
Well,
I thought I knew where we'd ended up, so I said so in HA Iraq.
Well, I mean, Mr. Dunlop's answer, we've ended up with HA Iraq. I mean, that is the answer that he will give.
Well, he's probably right as a matter of race.
Which as far as it goes, it's, I mean, if we just want the passage, it's at page tab 26, and
it's just the one I referred you to before lunch, isn't it?
It is.
Yeah. We need to go back to it.
So we need to go back to it, but we do end up there. But with the qualification which I didn't make clearly enough possible before lunch, that when we put that together with Academy number 2, we do get a subset of cases, smaller than Lord Carr would have liked, but nonetheless there, where the public interest plays out in a very different way, because the person who commits the offence is not an adventitious visitor to the United Kingdom, but someone born here, and in fact on my client's case, a national. And I think that is the sufficient.
Yes, thank you. Can I just, another thing I just quickly did over lunch was look at the grounds of appeal. And I think your submissions have covered all of them, though not necessarily quite in the way they're expressed there, with the possible exception of if we look at page 16 of the bundle, 3.11 and 3.12 at any rate insofar as it relates to family life. I mean, your general point about the private life is that he's been here all his life and has hardly ever been to Pakistan once to be married. But you haven't said anything about family life, and you may well have been wise not to. And you haven't said anything about the circumstances of his renunciation of citizenship, except in this general sense that he renounced citizenship for a particular reason, namely because he wanted to serve the rest of his, he hoped to be thereby to be able to serve the rest of his sentence in Pakistan, though of course he would then have had to remain in Pakistan after he'd finished serving it. I'm not encouraging you to make any other submission, but there are certainly hints in the skeleton argument of some submissions about trying to go behind the finding of the tribunal that he wasn't misled. I don't detect that you're pursuing that.
I don't want to go behind the finding that he wasn't misled. I do stay with what is said in paragraph 59 of the skeleton, page 36. which is possibly only another way of putting the submission I have made, which is that the ability to deport only arises because of the decision to renounce, which on my client's case was caused by the motivation of trying to be near to his father.
Yeah.
That's the trigger event, and any evaluation of where the public interest lies has to take into account that factor as well.
Okay. Thank you.
That then is my view.
Yes, Mr. Dunlop.
My lords, if I may give you the structure of my submissions, I'm intending to go into sort of three parts. The first is to take you back over the statutory materials. My learned friend has helpfully covered some of the ground, but there are some things I want to draw attention to. The second is to go carefully through the first tier tribunal decision. And again, there are some parts of that that my learned friend hasn't yet taken you to that I rely on. And the third is to address the grounds that have been pursued orally. And I hope that I've done most of the work in stages 1 and 2 and can take that section shortly by reference to my skeleton argument.
Okay.
Can I say, before I go to the statutes, just a brief word about something that was, a couple of things that were said in the course of this morning. It was said that the facts are very unusual, and then your lordship said that Parliament wouldn't have had this sort of situation in mind. Now, I accept that the facts of this case are quite unusual, but it is not all that unusual that someone who was a British citizen at the time they committed offences later loses their British citizenship and is subject to deportation action. That happens most typically in the context of terrorism-related offences, where dual nationals have their British citizenship taken away from them. And but it's not limited to terrorism-related cases. You'll be familiar, for example, with the cases of the Rochdale sex offenders. And they are going through that process. They've had their British citizenship taken away, those dual nationals, and are subject to deportation action. So I don't accept that Parliament wouldn't have had this sort of situation in mind of someone who was British when they offended, but not British at the time when deportation action is being considered. So, with that introduction, can I then take up the authorities bundle? And begin with the Immigration Act 1971, which is behind tab 1, and take you to page 4. Just, my learned friend's already taken you to subsection 5A. Just a couple of points to make, and helpful to have it in front of us while we do so. The first is that it uses precisely the same wording, is not a British citizen, as we find in section 32 of the UKBA and section 117D of the 2002 Act. It will be my submission, that's no coincidence. In each case, it's looking at British citizenship or not at the time of the deportation decision. That's the first point I wanted to draw out. The other thing to just draw out at this stage and have clear in our mind when we're looking at the later provisions is that this is a very broad discretion whenever the Secretary of State deems deportation to be conducive to the public good. It is not therefore limited to criminal offenders. Theoretically, you could be deported because of a suspicion which hasn't been proved in a criminal court, or because of activities such as exacerbating community tensions and so on. There's a broad range that's covered by 3.5a, not just criminal offending. The other thing I wanted to draw attention to, if we look at subsection 6, it's just an example of what Parliament does, and frankly anyone does with language, if they want to make it clear that there's a sort of extra qualification. Because what subsection 6 is about is a sort of another route by which someone may be liable to deportation. We've looked at 5, that's the Secretary of State decision route. 6 is this alternative route where it comes from a court recommendation. And again, it uses the phrase "is not a British citizen," which refers to the time when the court is making a decision about whether to recommend deportation. But what I'd sort of draw attention to is the use of a qualifying clause. So it's not enough that you be recommended for deportation. It's not enough that you be convicted of an offence. It has to be an offence of a certain kind. And we find out what kind of offence it has to be from the words in between the commas. So if we're picking up on the second line, if, comma, after he has attained the age of 17, comma, he is convicted of an offence. And that makes absolutely clear that it's not just any conviction which can trigger this, it's a particular kind of conviction. One occurred at a certain age. And what is striking is the absence of that kind of qualification in the language of section 32 of section 117D. It is not that those words don't have that kind of qualification, as we'll come to see. So last thing to draw attention to in this Act, if we go to section 5, you can see that there are effectively 2 discretions that the Secretary of State has under the Act, albeit we'll see it's qualified by later provisions. But just looking at the 1971 Act, is the discretion as to, first of all, whether they're actually liable to detention, whether their deportation is conducive to the public good. Then even if you sort of cross that threshold, there's this discretion here, 5.1. It says that where they fall within 3.5 or 6, then the Secretary of State may make a deportation order. So that was the sort of statutory framework. When we got to 2007 and the concerns when
Sorry, what are the 2 discretions?
Sorry?
What are the 2 levels of discretion?
The first level of discretion is the 3.5a level of discretion to decide whether or not deportation is conducive to the public.
Yes, I see.
And the second is, having decided...
No, now I understand.
Yes.
Yeah, okay.
So then we get to tab 2, UK Borders Act 2007. And if we move within it to section 32.1, you can see that there are 3 elements of the definition, and it is right that the present tense of is used there, but because the whole purpose of this provision is to govern and restrict the Secretary of State's discretion under 1971 Act, the time that you have to be all these things is the time when that decision is being made. And looking at the wording, these clauses are separate, and they are not qualified with subclauses in the way that section 3.6 of the 1971 Act Parliament could have said, under 32(1)(a), who is not and was not at the time of their offending, or at the time of their conviction, or at the time of their sentence, a British citizen. But Parliament didn't do that. Parliament could have said who is or was convicted at a time when he was not a British citizen in the United Kingdom of an offence. Again, they didn't do that. And similarly, a qualification could have been used over is sentenced in conditions 1 and 2. But again, Parliament didn't do that. And the obvious reason why Parliament didn't do that is because they wanted Section 32 to cover people like this appellant who had British citizenship, or may have had British citizenship at the past, at the time of their conviction, and so on, but do not have it anymore at the time when deportation is being considered. There is actually, and I respectfully endorse the points made by my lords, which we also made in our skeleton, about how this present tense can't possibly be intended to be literally used as a sort of literal present passive, because otherwise you'd cease being a foreign criminal the moment you sort of walk out of the court after your conviction or your sentence. And by definition, serious offenders, the conviction sentence, aren't likely to happen at the same time. There's also some case law on this, on these words, which reinforce the point that one shouldn't treat the present here as a sort of literal reference to an event happening in the present. And that case law is Hussain, which is behind tab 7. So if I can just leave the act to just take you to Hussain briefly. Just the issue in Hussain was whether or not someone is a foreign criminal in circumstances where they committed an offence before the UK Borders Act came into force. And so it was after the bill had come before Parliament, but before it had come into force, and it was said, well, look at the present tense, it can't possibly apply to me. And that argument was rejected by Mr. Justice Nichol, and the key parts of his reasoning are at paragraphs 20 to 21. And just to highlight his conclusions, paragraph 20, right at the end, the last sentence of the paragraph, he says that section 32, read in the light of section 59.4.2, which is what inserted it, must have been intended to cover those who had in the past been convicted, as well as those who were convicted after commencement. And then he also goes on at paragraph 21 to say that there are other reasons why the use of the present tense is not that significant. And he's talking here about conditions 1 and 2. And you can see, if you read at the end of subparagraph A and subparagraph B, the way he reads is sentenced in conditions 1 and 2 is as meaning is or was sentenced. And that reasoning was endorsed by the Court of Appeal in a case called AT, which is behind tab 9. And it's paragraph 11 at page 115, where Lord Justice Hooper, who's faced with exactly the same issue, says that he's read, the issue has been examined at greater length by Mr. Justice Nichol and Rashid Hussain. He reached the same conclusion that I have, and I agree with him. So if we go back to the statute, page 11, tab 2,
Yeah.
those authorities are respectfully right that the present tense is in 32.1 doesn't bear the significance that the upper tribunal attributed to it. In our skeleton argument, we've sort of pointed out there are three different ways of reading the phrase is convicted. And the wrong one, if you like, is as some sort of literal present passive of an event. There are two potentially right ways of reading it. One is to treat convicted as, without wanting to sound pompous, a participial adjective. So,
Yeah. Is a convicted person.
He's a convicted rapist or convicted murderer, exactly. And all that means is that at some point in their lives they have been convicted and likewise sentenced. And if you read it that way, then none of the sort of problems of a sort of literal present passive interpretation arise. The other way is to view it as a sort of example of the historic present. But I'd suggest the participial adjective is the better one. Nothing turns on that, though. The point is, it's not a literal present passive. If we then follow through the rest of section 32, subsection 4 is this sort of deeming provision that requires the Secretary of State to come to a certain answer on 3.5a discretion if the person is a foreign criminal. You have to find that deportation is conducive to the public good in those circumstances. And the point, as we'll come to see, was that Parliament was concerned that when exercising that first discretion, and that the decisions were being made that were too lenient. People were looking at people who were actually quite serious criminals and saying, well, that crime wasn't serious enough for deportation to be conducive to the public good. And it was that was the mischief that this was intended to protect against. And it was all related to excessively lenient decisions on what is a serious crime. And that's, of course, not the end of the story when it comes to deportation. There's a later stage where you look at, for example, you might look at Article 3 or Article 8 of the Human Rights Convention. And this isn't here to deal with that. There's no deeming about that. It's to deal with that first stage of which people are liable to detention. And so although subsection 5 says the Secretary of State must make a deportation order in respect of a foreign criminal, that is expressly subject to section 33. So it is not in fact automatic that you deport someone who's a foreign criminal, but it is automatic that if they meet a certain level of serious offending, then you must decide that they are at least liable to deportation.
Yes, the label automatic deportation is snappy, but it's not actually an accurate label. So, yes.
That's right. And section 33 sets out a number of exceptions.
It ought to be, sorry to spell it out, but
Yeah.
it ought to be automatic liability to deportation.
Correct.
Yes.
Section 33 sets out a number of exceptions. What Parliament could have done is they could have made an exception for my learned friend's case. They could have said, well, as an exception to this, if you were British at the time of your offending or your conviction or your sentence, then we won't automatically deem it. But they didn't do that. They have a number of exceptions dealing with other sorts of situations, some to do with EU law, some to do with other situations, but nothing for my learned friend's case. Just for the sake of clarity, you can see from subsection 7 over the page that if you read through this, section 32(4) applies despite the application of exception 1 or 4. And exception 1, you'll remember, is if deportation would breach convention rights. So the point of that is, even if you've got an overwhelmingly strong Article 8 case, we should still be doing, you should still be liable to deportation. You should still be deemed that your deportation is conducive to the public good.
Why is that worth saying?
It may not be. There was some reason I had a note to say that, but I can't quite remember what it was. I suppose the point is that it serves to emphasise that the sort of factors that my learned friend relies on, i.e. this is a strong Article 8 case, do nothing to affect what this enactment was trying to do, which was to make sure, never mind the Article 8 case you may come on to in the future, to make sure that people who've committed serious offences are deemed liable to deportation. Their deportation is deemed conducive to the public good, even if, regardless of the sort of factors about how long you've been in the UK and so on.
I haven't really thought about 7. Why does the application of an exception not prevent the making of a deportation order? Isn't that exactly what it does do?
Well, I think that first bit of it is saying that effectively, if you make a deportation order, and a court later decides that an exception applies, you haven't acted unlawfully by making that deportation order in the first place.
Well, but you've got to apply. You may have to consider. You, the Secretary of State, ought to be considering first whether the exception applies.
You should.
And if it does, you don't make the order.
That's right. That's what you should do. I agree. I think it's trying to sort of.
Well, it's a puzzle. It's not a puzzle we have to solve.
No,
it's only because you draw our attention to it. There probably is a simple answer, but since I don't think this really, since you haven't got it at your fingertips, that's not trouble with it.
Is it that the Secretary of State is not compelled to make the order?
Well,
I mean, section 32(4) and 5 effectively restrict the discretion, i.e. you must. For example, subsection 5. If an exception applies, it's not must. But is it trying to say you could still?
I think I prefer not to try to answer that conclusively in case I get it wrong.
Yes, it's
but
hard
as you
to think of a case in which, even though you mustn't, even though you don't have to because an exception applies, you nevertheless could, despite the fact that the exception applied.
I suppose. Sorry, I think actually. Sorry, I have had time to think about it, and I think my Lord Justice Snowden actually must be right about that. It changes what would otherwise be a duty into a discretion, but I don't want to spend too long on that. But
no.
So, for example, if the Secretary of State thinks the foreign criminal is under the age of 18, then there will still be a power to make a deportation order, albeit that it wouldn't be through the prism of 32.
All right. Well, I think we won't go there.
Yes, quite. The only other thing to point out is section 34, subsection 1. It's up to the Secretary of State when she chooses to make a deportation order. So it can't be that she has to sort of pounce right at the end of the criminal proceedings. Otherwise, she's lost the chance and they're not a foreign criminal anymore.
And she generally doesn't. She waits towards the end of the custodial part of the sentence.
Quite. And then for the explanatory notes, my learned friend ended up saying that they don't help him. In my submission, they do actually help me. And so I'll just draw attention to two bits that do help me. The first is page 18, paragraph 103, the second sentence. Here, it said that a foreign criminal in this context means a non-British citizen who has been convicted in the United Kingdom of an offence. And that, I would say, is consistent with my construction. Is convicted. Convicted there is used as a participatory adjective and means the same thing as has been convicted. And then the other thing that in my submission helps me is paragraph 107, first sentence. This section gives effect to the commitment given in the Home Secretary's statement to create a direct link between deportation and the commission of a crime of the appropriate level of severity. Now, I say that helps me because my learned friend's approach would be to break that direct link and not simply say murderer, therefore foreign criminal, but to say, well, actually that you have to sort of it's not as direct as that. You have to sort of go through the process of thinking whether they're British at the time of their offending, which may not even be clear, given they may not know the precise date of the offence, etc., etc.
Well, I think his point was, unless I've misunderstood him, was the date of conviction.
Well, actually, I thought that was his point when I read the skeleton argument, but when my Lord Justice Arnold put it to him, and put a couple of scenarios, he ended up saying, I thought, by answering the scenario 1, that really the key date was the offending.
I remember that exchange, but I didn't pick that point up. You may well be right.
Because I think what my Lord put to him, well, scenario 1 was that you're, if I remember it rightly, British at the time of offending, not British at the time of conviction or sentence. And my learned friend said, well, you wouldn't be caught by section 32. So actually, in his oral submissions, the key date was the date of offending, not the date of conviction.
Yes. No, that's my note shows that as well.
The first sentence of paragraph 108 is, could be read against you. It talks about new statutory framework for the automatic deportation of certain non-British citizens convicted in the United Kingdom. I mean, isn't the natural reading of that they are non-British at the time of conviction?
Well, that may be a reading of it. It's certainly not the only reading of it. It could also cover non-British people, non-British citizens who were at some point convicted of a qualifying offence. It certainly does not make it clear that the intention was only to cover people who were non-British at the time of conviction.
So you read the second line as meaning non-British citizens who have been convicted in the United Kingdom.
Yes. Which is the reading of, which is how it's put at 103. So if I then one final point before we move on from the UK Borders Act 2007, just to take you back to the conditions at subsection 2 and 3 of section 32. Those conditions set a certain level of seriousness of offending. So either you have to have a sentence to a period of imprisonment of at least 12 months, or it has to be an offence for which you are subject to a period of imprisonment, could be less than 12 months, but it is a particular kind of offence, one specified in an order that identifies certain serious sorts of offences, offences of violence and so on. The reason I draw that to your attention is because when I come on to the 2002 Act, it is not synonymous, it is not covering the same ground. So if we go to that Act, it covers a wider range of criminals, and deliberately so. And just to explain, it's because the purpose of this is something different. The purpose of this Act is not a sort of direct link to deeming certain offences as ones that are serious enough to make your deportation conducive to the public good. The purpose of this Act is to ensure a structured approach from tribunals or courts who are considering the application of Article 8 to the deportation of people who've committed criminal offences, not just serious offences, a much broader range of criminal offenders, as we'll see. My learned friend took you to 117A, and I respectfully agree with your lordships in pointing out that really what 117A shows is that this is guidance for courts or tribunals, and the key time is the time when those courts or tribunals are considering the public interest question. They are deciding, would deportation right now reach Article 8? And so that is the key time when we come to look at the definition of foreign criminal. 117C, as my learned friend pointed out, sets out the principles to apply when considering the deportation of foreign criminals. As my Lord Justice Snowden pointed out, it is recognised by Parliament in subsection 2 that the public interest in the deportation of criminals is not a fixed thing regardless of what the offence is. It increases the more serious the offender. And when we come on to Akinyemi 2, in my submission, that judgment really does no more than reflect that point which is enshrined in the statute. Exceptions 1 and 2 are what I would describe as exemplars of success. My Lord Justice Underhill described them as a sort of shortcut, but I think I prefer to say exemplars of success for foreign criminals who have not been sentenced to 4 years or more. So if I'm right and we're in 117C, then merely satisfying one of these exceptions would not...
Sorry, why would you be 117? Oh, I see you. Yes, sorry. We are always in a 117. I'm being slow. Yes, do carry on. Yep.
So these are exemplars of success for those in sort of under 4-year sentences. And of course, in our case, we've got someone much more than 4 years. So meeting these exceptions would not be enough for him. But exception 1 is perhaps the most important one because it covers the considerations which are generally the key ones in a private life case. And there are 3 elements, and there's no dispute that this appellant meets A and B, and those were indeed the findings of the first stage tribunal. But he did not meet on the findings of the first stage tribunal C. For a large number of reasons, the first stage tribunal did not think that there would be very significant obstacles to his integration into Pakistan. And that's very important when you come to weigh the proportionality balance. It doesn't even meet the kind of exemplar situation for a medium offender, if you like. Nor did he meet exception 2, which is to do with family life. Now, if there's no success on exceptions 1 or 2, then you go to C6. And this will be very familiar to my Lord Justice Underhill, but in case it's helpful, that there is a sort of drafting error here, by the by in this case, but one has to go to 117C6, even in the case of a sort of medium offender, if they haven't succeeded on exceptions 1 or 2, and that's what the Court of Appeal decided in NA. You always have to get to the very compelling circumstances bit if you don't win on the exceptions, even if you're a medium offender. But I respectfully agree with what my Lord Justice Underhill put to my learned friend, that this very compelling circumstances test is quite capable of taking into account all the things that the ECHR Article 8 case law requires you to take into account. And before I leave 117C, can I just take you to that case of NA? It'll be relevant to the sort of later part of the submissions when we look at the actual decision in this case, but it also explains how to read 117C. It's behind tab 12. And the relevant parts are paragraphs 30 to 32, where the court tries to explain how to sort of put into practice this guidance in 117C. And what the court says in paragraph 30 is that if you're sort of a serious criminal, you're so paragraph 30 says in the case of a serious offender, what they're talking about there, a serious offender is someone with 4-year plus sentence. You can only make out a sort of bare case under exceptions 1 and 2, then you shouldn't succeed under the very compelling circumstances test.
Yeah, this was just to meet the point that over and above exceptions 1 and 2 meant you couldn't rely on exceptions 1 and 2.
Yes, I mean,
which was obviously not what was intended. It's just rather clumsy drafting.
Absolutely. It was followed on from the argument about how the purpose of subsection 6 is not to sort of ring fence and so you have to bring in wholly new points. But he does make the point, which is important for our purposes, that if you can only make out a bare case on exception 1, then it'd be impossible to say that there are very compelling circumstances. And we would say a fortiori when you can't even make out a bare case under exceptions 1 and 2, as this appellant failed to do. And the other point that's made here under section 32 is that in the case of a medium offender, if all he could advance in support of his Article 8 claim was a near miss, in which he fell short of bringing himself within either exception 1 or exception 2 would not be possible to say that there are very compelling circumstances. So we say in this case it's even worse, because what we have is effectively a near miss, but a serious offender.
Yes, but you're not suggesting, in fact, you're clearly not, because something you said a minute or two ago. If there is something very unusual in the situation, which doesn't fall within exceptions 1 and 2, in this case, what is being said is that this is someone who's been a British citizen all their life and only gave it up in very peculiar circumstances. That could, in principle, be a very compelling reason, irrespective of how they scored on exceptions 1 and 2. In principle.
Yes, I accept that none of this is supposed to be a straitjacket. I think lawful residence in the UK is expressly covered by exception 1, but I agree. I mean, if one had a different factual scenario, different factual findings, and this was a British citizen who was somehow tricked by the Home Office into renouncing their British citizenship, then plainly that would be a circumstance that could be very powerful and could tip the balance.
Right. Well, right.
So going back to the statute, if we go to page 24 of the bundle, at section 117D subsection 2 on page 24, then foreign criminal, again, there are 3 elements. Again, the first element is the same as from the 1971 Act, is not a British citizen. And the obvious meaning of that is not at the time when the tribunal or court is considering the public interest question. And here, fortunately, they haven't used the participle adjective, and so there can be really no doubt that what it is talking about is someone who is not at that time a British citizen, but in the past has been convicted in the UK of an offence. And there's no qualification, there's no sort of words in commas to say has been convicted at a time when he was not a British citizen or so on. So
it's almost as if the draftsman started with section 32, subsection 1, and noticing as the process of copying it out was occurring that the word is in B didn't quite make perfect sense, and therefore substituted the intention, what was obviously intended has been.
Well, I wouldn't disagree with that. It's far be it from me to suggest what was in their mind, but I think they certainly eliminated the ambiguity that had been there from the word is in the UKBA and put beyond all doubt what this is really meant to cover.
Because this is later in time, isn't it? This is 2014, this amendment.
Yes. And frankly, if you wanted to cover people like this appellant, you would draft it like this. If you wanted it not to cover them, you draft it very differently. Yeah. And the only other thing I think this is the only other thing to point out, is that it covers a broader range of offenders. So it's not just those with a 12-month sentence or in that kind of order that sets out particularly serious crimes. It also covers, for example, persistent offenders. There might be someone committing very, very minor crimes a lot of times, and they would not be deemed a foreign criminal under the UKBA. But Parliament wanted the structured approach to be applied for them. And surely Parliament would have wanted the same structured approach in this case, especially when that structured approach is perfectly capable of taking into account the unusual circumstances of this case. One other thing I was going to point out, well, the case of OH Algeria, my learned friend referred to, I don't need to take you back to it, but what Justice Irwin interpreted has been convicted of meaning was has at any time been convicted. And that, in my submission, if anything, supports my case. Obviously, we weren't dealing with the same issue, but he didn't say has at a time when he was not a British citizen been convicted. He said has at any time. And one other thing to draw out from this statute, if you look at subsection 5, if any question arises for the purposes of this part as to whether a person is a British citizen, it is for the person asserting that fact to prove it. And I stress the word is because the understanding of Parliament was that the only potential issue might be whether at that time of that court of tribunal hearing that person is a British citizen. They don't here address the whether a question might arise as to whether the person was a British citizen. They don't place too much emphasis on that, but it does tend to show that the focus was on British citizenship at the time of the court of tribunal's decision. The rules, I don't need to take you through the rules. I just say two things about them. The first is that the ones we have in the bundle are the ones that were enforced at the relevant time.
Yep.
The second thing is that my Lord Justice Underhill were right to say that the rules are very deliberately in sync with 117A to D. And that's why 117A to D don't actually need to apply to the Secretary of State, because she or he's got some rules that are in sync, telling her what to do. There's one tiny thing, tiny difference, which actually cropped up in OH Algeria. I'll just point it out almost in cases of interest, just or to make sure I don't sort of say anything that's wrong. There's one tiny difference, which isn't material, but if you look at 117C7, that provision there, the considerations in subsections 1 to 6 are to be taken into account where a court of tribunal is considering a decision to deport a foreign criminal only to the extent that the reason for the decision was the offence or offences for which the criminal has been convicted. That has no equivalent in the immigration rules. And in OH Algeria, my Lord Justice Owen accepted my submission that the reason that has no equivalent is because it's telling tribunals what to do with the reasons they've been given by the Secretary of State. You have to look at the reasons of the Secretary of State, and you know, if an offence isn't mentioned in that decision letter, then you can't take it into account. So that's the only difference between the rules and 117A to D. So I can then, those are my submissions. That's the first stage of my submissions. That's the statutory law.
Yep.
Now I'll go on to the first tier tribunal decision, and if you like, the sort of grounds 2 to 6. And I want to do that by going through that decision quite carefully. So it begins at page 157 of the main bundle. Paragraph 4 and sets out the appellant's case. Paragraphs 5 to 7 set out the refusal letter. And frankly, it just doesn't assist my learned friend's case what was said when all the tribunal was doing here was sort of citing the refusal letter. It was not part of the tribunal's reasoning. We then get on to the legal framework, and at the top of page 160, very top of that page, so part of paragraph 12, you can see that the judge has assumed that the appellant was not a foreign criminal for all purposes. The rules, and what she had to do. We say she was wrong about that, but as you can see from her reasoning, if anything, it worked to the appellant's favour. And she said that it was a sensible thing to do, to try and figure out what the answer would be if you were applying 117A to D, or the exceptions in those provisions. I respectfully suggest that it was a sensible thing to do. It is a helpful thing to look at those provisions. I mean, actually, in fact, she was obliged to, but and that in some ways is fortunate that she did it, because she was supposed to do it, even though she didn't realise that. What she does in practice is to look at the...
Yes, I may have been a bit unfair to her by saying that she overcomplicated her task.
Well, it is definitely a complicated task, however one approaches it. And I think the fair thing to do is to look at all the matters she took into account, regardless of which particular sort of bucket she put it in.
Yeah.
So when one does that, what one sees is a thorough and fair and reasonable analysis of the factors that weighed on both sides, and that ultimately lead to the conclusion that deportation would be proportionate. So paragraph 14, there's an assessment of the best interests of children. There's no criticism made of that assessment. Then paragraph 15 is a very important factual finding, which my learned friend rightly does not attempt to go behind. And that finding is that the appellant was not misled that he could get his British citizenship back if he was not transferred to Pakistan. And you can see that finding spelt out over the page on 161. It was argued, if I pick it up about sort of 7 lines down, it was argued that I should consider proportionality against the backdrop that he was told by officials his citizenship would be reinstated if he was not transferred to Pakistan. However, on the basis of the evidence available to me, I'm not satisfied I can reach that conclusion. I find the appellant made his decision to renounce his citizenship as he wanted to be transferred to Pakistan, and his decision was motivated for the reasons in his witness statement, namely wanting to be near his ailing father. Now, that is a very important point, which is referred to later on, and it weighs significantly in the balance. This is, I would say, a very far from the Akinyemi case. My learned friend referred to it as Akinyemi plus. I would say it's Akinyemi minus, because Mr. Akinyemi always wanted to stay in the United Kingdom. He had a right to British citizenship when he was a child. It's not really his fault that he didn't exercise that right. And he tried to become a British citizen, but all but too late after the statute had changed. He was also, as your Lord pointed out, convicted of a far less serious crime. Compare that to this case, where the appellant voluntarily renounced his British citizenship so that he could travel to Pakistan in circumstances where he must have realised he may never be allowed back into the UK. So I think that might be a point to address my learned friend's points about dubious penalisation. There are 2 things I wanted to say about that. One is that my Lord Justice Underhill was quite right that deportation is not a penalty, and authority for that, fortunately, is actually in the authorities bundle. I won't take you to it, but I'll give you the reference. It's the case of AT at tab 9, paragraph 27. Secondly, if one just thinks about what the rule of dubious penalisation is about, it's about avoiding a sort of unfair punishment that couldn't have been foreseen. And that has absolutely no application here, where it could have been and must have been foreseen that by voluntarily renouncing his British citizenship, he may at some point be deported and never be able to come back. In fact, that's what he wanted.
It's a slight puzzle. We haven't actually been taken to paragraph 24 of the witness statement. As long as he, the deal, if it had worked, would have been repatriated to serve the rest of his sentence in Pakistan. So he would only have seen, he wouldn't have been able to be directly looking after his father as long as he was in prison.
Correct.
And assuming he wouldn't have been let out any earlier than he would have been let out here, it's not quite clear to see what the advantage would have been, but maybe.
Well, I can see two advantages. I can't say that these are in his mind, but one would be that his father could visit him in prison.
Yes, quite.
And the other would be that either, I don't know whether Pakistan has a sort of system of allowing leave from prison at the end of the sentence, but whether at that point or after the 15 years had passed, if his father was still alive, he would be there with him.
But also communication might be easier.
Yes.
Yes. But
anyway, it doesn't really. One can't help asking these questions, but the finding is what matters.
Yes, and the trigger for all this was initially he was refused a transfer on the basis, well, you're a British citizen, you might come back, and his response to that was, okay, I'll give up my British citizenship. Implicit in that is that he must have realised he might never be allowed back.
Yeah.
Paragraph 16. The tribunal made an error in the appellant's favour. The tribunal thought that the very compelling circumstances test didn't apply, you can see. So the significance of this is, even if my learned friend were right on ground one, this appeal would still fail because the tribunal did what he says they should have done, of applying a lower threshold. Paragraph 17, under the subheading Private Life, looks at exception 1, and in essence, in paragraph 17 itself, the tribunal quite rightly accepts that subsections A and B of that exception are met, that there's been the lawful residence, there are the ties to the UK, the social and cultural integration in the UK. And then in paragraph 18, the tribunal begins to consider what you might call subsection C, the point about could he integrate into Pakistan, and the tribunal begins by having regard to all the leading case law on this, including Kamara and so on. And then at paragraph 20, we get detailed reasons for finding that there would not be very significant obstacles to integration. And all of these reasons are important when one comes to look at the proportionality balance. It's a key part of any private life Article 8 case. How difficult would life be for you in this country to which the state is planning to transfer you? Answer, not that difficult. And there are 10 reasons given for that in paragraph 20. The first point is around about the third sentence, that he has his family are all of Pakistani ethnicity, so it's likely he's familiar with Pakistani culture and traditions. The second point is that he was prepared to be repatriated to Pakistan, and that goes back to that important finding earlier, what he wanted. And he must have been prepared to serve out the rest of his sentence in Pakistan, in a Pakistani prison. And then the fourth point, he would have been well aware of what that entailed. And I pause there to say, well, what that entailed is never being allowed back. Well aware of what that entailed, and this did not deter him from renouncing his British citizenship so he could move to Pakistan. And then we have a little bit further down the point that he was of working age, the point that he was of good health, the point that he has transferable skills, the point that he can speak basic Urdu and can acquire greater fluency in Pakistan, the point that he would be likely able to secure employment, and then finally the point that he does have extended family there and he could get support. So all of this leads, all these 10 points lead to the conclusion of paragraph 21, he would be able to integrate in Pakistan. So then paragraphs 22 to 25 that sets out the reason on family life. That's not challenged, I don't need to go through it. The essence of it is it's not unduly harsh on his wife, who he married, I believe, by telephone when he was in prison, for her to remain in the UK while he...
So he married by telephone, right?
Yes, I believe so. Yes. It was one of those marriages conducted in the absence of the person. I believe it was a sort of.
I did. Perhaps. Sorry, I was just surprised. I knew he married while they were in prison, so
yes,
that's all that matters. Yes.
Then paragraphs 26 to 29 probably could do with a new subheading, because really what they are about is the very compelling circumstances over and above test. And what's important to bear in mind, most of all, with paragraph 26, first sentence, I consider all the matters relied upon collectively in order to determine whether they're sufficiently compelling to outweigh the high public interest in deportation. I'm entitled to consider both new and the same factors again. So just because something is put into the kind of exception 1 bucket doesn't mean that it must forever stay there.
Right.
It's also relevant to varying compelling circumstances. Paragraph 27, first sentence, I do bear in mind he was formerly a British citizen, and that does carry substantial weight. Now, pausing there, I suspect if the upper tribunal decisions and the Akinyemi cases had a sentence like that, well, I know that they would have been a lot easier to defend from the Secretary's point of view. If you're saying this is an important factor you have to take into account, it weighs in his favour, well, that's exactly what the tribunal did. What they do also take into account is the point in the next sentence, and I agree with your lordship that there's a sort of grammatical or typographical error here, and I think you can cure that by either changing the full stop to a comma and putting although in the lowercase, or you can change although into however and start a new sentence that way. But either way, what is being said here, what is being taken into account are the two relevant aspects of his British citizenship. on the one hand, there's the fact he was a former British citizen. That counts substantially in his favour. But on the other hand, there's the fact that he gave it up voluntarily. He was not misled into doing so. And then paragraph 28, we have the comments on risk of offending, and I respectfully agree with the Upper Tribunal that a comment that being recommended for parole suggests a very low risk of reoffending in the future is not the same thing as a finding that there was a very low risk of reoffending. You can't build that sort of significance into it and turn it into a finding. It's a mere suggestion from that. And I should respectfully suggest that what really the Tribunal was doing here is what your Lordship sort of said that tribunals should do in HA Iraq, which is to recognise that it's very difficult for them to make findings on risk of reoffending, and it's not always necessary or appropriate for them to do so. And in this case, I would say that even if it were a low risk of reoffending, given how serious the index crime is, that's a risk that for deportation purposes the public shouldn't have to bear. Even if there is only a sort of 5% chance you murder someone else, that is not conducive to the public good.
Does that submission amount to the proposition something like the following? Murder is a very serious offence. Generally speaking, we don't want people who've murdered others to be in our society. Normally we can't do anything about it because if the person is a British citizen, they can't be deported. But if they aren't, the Secretary of State should take advantage of that.
Yes, I agree with that. Certainly, I mean,
is that a legitimate line of reasoning? Is probably the question, the way I should have put the question.
Yes, it is. It is a legitimate line of reasoning. There are, as we'll come to see, different facets of the public interest. But just starting with the first one, if we're talking about risk of reoffending and protecting the public, then if someone has committed, frankly, the worst crime that you can think of, i.e. deliberately taking another person's life, and there is a risk of them doing it again, even if it's a low risk, then it's absolutely right that the Secretary of State should, if she's legally allowed to do so, deport that person, protect the public from that person. That's the Secretary of State's duty, protecting the public.
Subject, obviously, to other overriding circumstances that we've been looking at coming into play. I was
absolutely, but if one's
focusing on the risk of reoffending, really.
Yes, but so in all of these Article 8 cases, what you're effectively balancing, I would submit, is the sort of the interests of society generally against the interests of the individual, or in a family life case, maybe the family, but we're really dealing with a private life case here. So if we're looking at the interests of society, this UK society, the society the Secretary of State is in charge of protecting, it is plainly strongly in the public interest to deport a murderer, even if their risk of reoffending is low.
And you say that doesn't change because of the fact that the person, when they committed the murder, was British?
No, it doesn't. I don't see that makes any difference. I mean, from the perspective of the member of the public who could theoretically, in a 5% chance, be killed, it doesn't really matter to them whether the person who kills them was a British citizen or not the last time they killed someone. I don't want to sort of, trivialise it, but I mean that's what it boils down to, about protecting the public.
But as I understand, your key point here is that there is no finding that there is no risk of reoffending. We bear
Absolutely.
in mind that murder, even murder, covers a wide range of circumstances and can extend, for example, to so-called mercy killing, where it's close to assisted suicide.
Absolutely. There is no finding of no risk of reoffending, and nor could there be. I'm not going to try and sort of go beyond or behind the reasoning of the tribunal or try and sort of re-argue the facts. But so that you know, the parole board's decision is at pages 202 onwards, and they find, notwithstanding a low risk of reoffending, a medium risk to the public because of the severity of the previous offending. And the conclusions here are perfectly in line with that. Paragraph 30, looking at here, this is where the tribunal begins the sort of freestanding proportionality analysis. They've gone through the 171A to D process, and then they're looking again.
Was I also being unkind to the tribunal when I said that this was, in a sense, reproducing? Because isn't this really what you've done at paragraphs 26 to 28?
To some
When you're
extent,
doing very compelling circumstances, all you're doing is you're doing a proportionality exercise, but following the steer as to the weight to give to the public interest.
yes, I think that's right, that proportionality and very compelling circumstances are not different things.
Yeah.
One of them, you sort of take into account the exemplars and steer from Parliament, but yes, they are the same thing. The reason that the judge did that is because she believed...
Yes, I think what she was doing, she was thinking, this has all been a very useful thought experiment, what I would do if this was a foreign criminal case. I've done all that, but now I'm going to do the 35A exercise, which is pure proportionality.
Yes, and the reason she thought she had to do it again was because she was of the same view as the appellant is, which is there's a sort of lower threshold outside 117A to D. I'm not sure that's right, but that was another sort of, if it was an error, it was in the favour of the appellant.
Yes, quite.
And she says that about must not assess his claim against the higher threshold. And then I just focus on the last sentence. Given the nature of the offence, I expressly take into account that deportation is conducive to the public good and in the public interest. And I stress the words given the nature of the offence. This is then unpacked a bit at 32A. But the point is, what she was not doing is treating the public interest in deporting foreign criminals as a fixed value, as it were. She was not doing that which Lord Justice Ryder said should not be done, sort of treating it as something that isn't movable. She wasn't just saying foreign criminal, therefore public interest. She looked specifically at the nature of the offence. And that's quite in line with 117C2, which talks about how the strength of the public interest increases given the seriousness of the offence. And this was an extremely serious offence. And paragraph 33, she duly takes into account all the matters, some of which is covered before, but some just reiterates things that count in the appellant's favour, including, as my Lord Arnold pointed out, the fact that the appellant has only lived in the UK, and so on. Notwithstanding that, she comes to the conclusion that deportation is proportionate to the legitimate end sought to be achieved, namely the prevention of crime. And that was an unimpeachable conclusion. It was frankly an unsurprising conclusion, and it was one that had regard to all the relevant factors, which were all addressed earlier on in her factual findings. So, that deals with the second section of my submission, going through the judgment, and then hopefully I can take the other points relatively quickly, although I will just need to go back over OH and Akinyemi too. So if I take you to our replacement skeleton argument, it begins at page 66 of the core bundle. The submissions begin page 75. And paragraph 23 is just setting out the appellant's submissions. Paragraph 24 I've dealt with why we shouldn't be bound by concessions below. My learned friend very properly and reasonably hasn't taken a point on that, so I don't need to go over any of that. Paragraph 25 sets out our case in outline. And I think I can just limit myself to sort of going over the outline without going through all the detailed submissions that follow it. The principal point is that the relevant time for assessing the three elements of the definition in section 32 and indeed in section 117 D2 is the time when the decision is being made. So in section 32 it's the time the Secretary of State is considering deportation. Section 117D is the time when the court or tribunal is considering Article A. And it therefore follows that the appellant was a foreign criminal both under the UKBA and under the 2002 Act because he was not British both at the time of the deportation order and at the time of the first tier tribunal hearing, and had in the past been convicted and sentenced in ways that met the conditions. The fallback argument is there at 4, which is even if I'm wrong about section 32, I'm right about 117D. And the fifth point is that on the facts of this case, it's actually ground one on success on ground one wouldn't really help my learned friend because of the way that the tribunal approached it and the way the Secretary of State approached it. So that, I think, deals with ground one, and I don't need to go over all the more detailed points in the skeleton because I hope I've picked up the key ones when we were going through the statute. If I then move on to ground two, that begins at page 85, paragraph 58. The first point is, if you look at actually how this ground was pleaded, it was pleaded as a criticism of the upper tribunal.
Yes.
Not the first tier tribunal. In fact, I don't want to embarrass my learned friend because obviously he wasn't the author of the skeleton argument which we have, but
You just want to embarrass Mr. Kubo.
I don't want to embarrass anyone. But I think I'm entitled to point out that the skeleton argument says that the first-tier tribunal took the right approach, and I've quoted from that skeleton argument, or we've quoted from that skeleton on paragraph 60, because the reasoning of the tribunal simply doesn't say anything about public revulsion or public confidence. And so it's something of a red herring, to be frank. And I think I'm entitled to point out that, as pleaded, the case against me accepts that the first-tier tribunal was taking the right approach to this, and only criticising the upper tribunal. But I would like to help your lordships know what the law is.
Yes,
on this.
I'm wondering whether I've been a little bit too glib about exactly where the law has ended up after, in the light of Lord Wilson on the one hand and Lord Kerr.
Well, the short answer is no. I entirely agree with your lordship.
Right.
And that's it's a simple application of the principles of precedent.
Yes.
But I think we might need to go back briefly, at any rate, over those authorities. So if we go to OH Serbia, which is behind tab 8 of the authorities bundle.
Yes.
So OH Serbia is an Article 8 deportation case. Obviously, it's a Court of Appeal decision. It is therefore, as to its ratio, binding on you.
Yes.
So are the other Court of Appeal cases it refers to within it.
Yes.
And
Kenya, I see
Kenya.
at 12, which was where all this started.
Absolutely, exactly. So, just so you know that the facts, and you can understand what these facts are when you come to see what Lord Justice Ryder sort of distinguishing the facts, if you like. You can see from paragraph 3 that OH committed a very serious offence of violence. The details are at paragraph 5. He got a 4-year sentence for it. It was an offence involving attacking someone with a razor knife, narrowly missing the jugular vein. If you move within the judgment to paragraph 14, Lord Justice Wilson, as he then was, refers back to N Kenya, and the fact, and as you rightly say, N Kenya is where these principles started, and N Kenya was an even more serious crime, but still not as serious as our case. It was someone who abducted, threatened to kill someone, falsely imprisoned them, and raped them 3 times, and was sentenced to 11 years. And in the context of that case, the Court of Appeal in N Kenya, which are cited at the bottom of paragraph 14, there's a judgment of Lord Justice May talking about what needs to be taken into account. You can see the kind of perhaps the most important part of it over the page, top of 106.
Well, we just note at the bottom of 105 the phrase society's revulsion at the seriousness.
Yes, yes. So it didn't come from Lord Justice Wilson.
No.
It's paragraph 65 over the page, top of 106. The risk of reoffending is a factor in the balance, but for very serious crimes, a low risk of reoffending is not the most important public interest factor. And that really is consistent with what I was saying, is when you're talking about something like murder, or in that case attempted murder or something, very serious crimes, then a low risk of reoffending really isn't enough to help the deportee. It's really not that big a factor. And then Lord Justice Judge, we have his judgment where he talks about broad issues of social cohesion and public confidence in the administration of the system by which control is exercised over non-British citizens who enter and remain in the UK. This appellant may not have been a non-British citizen when he was born or for much of his life. He is a non-British citizen now, and he is remaining in the UK. So it's still part of the same system. Paragraph 15 is where Lord Justice Wilson summarises the principles that he gets from N. Kenya. And principle A is that the risk of reoffending is one facet of the public interest, but in the case of very serious crimes, not the most important facet. And then another important facet is the need for deterrence. A third, C, is expression of society's revulsion and in building confidence in the treatment of foreign citizens who have in the past committed serious crimes. Then there's a final point about how primary responsibility for the public interest resides in the respondent, that's to say the Secretary of State. And that is something that needs to be given significant weight because they're the democratically elected person with responsibility for protecting the public. Now, if one looks at C, what effectively Lord Wilson, as he then became in Hesham Ali, what he sort of drops are the words expression of society's revulsion at serious crimes. What he keeps is in building public confidence. And frankly, dropping the words expression of society's revulsion doesn't affect the key point. It is still an important facet in the public interest, is building public confidence in the treatment of foreign citizens who have committed serious crimes. Whether
Yeah, but I mean, the real thinking behind it is, it's neat of you to divide it up that way, but not the two are really separable. Because why might the public not have confidence in the system if someone like this wasn't deported? Answer, because the public expects that people who have committed serious crimes, about which they feel revulsion, will not be allowed to stay in the country. You can't. The two fit together, don't they?
Yes. That's right. There's a strong connection between the seriousness of the crime and the effect on public confidence if that person is not deported. So, public confidence in the system, I'd respectfully suggest, is not likely to be that shaken if you fail to deport a not particularly serious offender who's lived their whole life in the UK. A sort of, let's say, for the sake of argument, a sort of Akinyemi type of person. Public confidence, on the other hand, would be shaken if there were no deportation of someone who's committed an extremely serious offence of murder, deliberate killing, and voluntarily gave up their British citizenship.
Yeah. Oh, I see how you put it. I'm just interested in what the position is in law. We haven't yet got to. Perhaps you're being very economical, which I appreciate. We may not need to go back to Hesham Ali, but what Lord Wilson disavowed was the emotional language of revulsion.
Yes.
But there must be an underlying reason why the public why public confidence requires people who have serious crimes to be removed, and that must be, put it very crudely, a feeling that such people should not be allowed to stay in the country.
Yes.
And that's irrespective of, it's quite clearly analysed separately from the question that they actually pose a risk of doing it again.
Yes.
Yeah, okay.
So, as you say, I won't go back over Hesham Ali unless you want me to, but you're right to say that effectively it's a private debate between Lord Wilson, who's part of the majority, and Lord Kerr, who's the only dissenting judge, and Lord Reid, who speaks for the rest of the majority, as it were, doesn't sort of take a side on this debate.
So is this? I don't want to rush you, but really comes down to this, doesn't it? It is. We could spend quite a lot of time. I suspect the position is this: that Lord Kerr actually just disapproves of this factor C altogether.
Yes.
Lord Wilson, it's a little bit ambiguous how much he is rowing back, but he's certainly not rowing back totally from factor C. But neither of them are the majority. The majority don't speak on this subject. We remain therefore bound by the stream of Court of Appeal authority, of which this is one element, and which was recently summarised and reaffirmed in HA Iraq.
Exactly.
So, end of story as a matter of precedent.
End of story as a matter of precedent. And so I think all that remains for me to do is to explain, in fairness to Lord Justice Ryder, what I think he was trying to do, which was not to kind of upend the rules of precedent, but rather to make a sort of factual distinction but without really spelling out exactly what the facts were that led to that distinction. So it's at page 521 behind tab 35. So it's the last sentence of paragraph 52 on page 521. The first bit is expressly obiter. Effectively, what he's sort of saying is that if this ever gets to the Supreme Court, I'll be on Lord Kerr's side of the argument, as it were. But he then limits his reasoning to saying that Lord Wilson's observations made in a different context to the facts of this case and is either inapplicable to the facts or would not tend to strengthen the weight of the public interest in deportation in this case. And it is not spelt out why there's a sort of factual distinction between what Lord Wilson was talking about and that case. Ultimately, what he must have been saying is on the facts of this case, public confidence would not be in any way shaken by a sort of failure to deport this person. And no doubt that is partly because that person has been in the UK their whole life, but it's also partly because their crimes were not all that serious compared to what we have in this case. Of course, death by dangerous driving is a serious crime, and he knew that he was prone to epileptic fits and he shouldn't drive. Absolutely no way minimising that seriousness of that, but it's a very different thing from deliberately taking a life, as this appellant did. And you were seeing from the judicial sentencing remarks how brutal that was. And I submit that this case, factually, is on the Lord Wilson side of the line. This is a case where public confidence would be shaken if a murderer who gave up their British citizenship because they wanted to go back couldn't be deported. But that is all something of a red herring, as I said, because that's not actually a key feature.
Well, that's been a useful exposition. So, but we were going back to your skeleton argument.
Yes. So going back to my skeleton argument. that deals with ground 2. Ground 3, I understand that my learned friends made no concessions, but I didn't really see any of the points under ground 3 being developed orally, so I don't want to take up your time by sort of orally making submissions myself on it. Effectively, the key point was he accepted he wasn't going behind the factual findings, including the factual finding of no misrepresentation. And ground 4, again, actually as pleaded, has the same problem as ground 2. It's an attack on the upper tribunal when it's really the first tier tribunal that matters. And I've dealt with the first tier tribunal and how they looked at the risk of reoffending in the course of going through their decision.
Yeah.
Ground 5 is something that must fail on 2 grounds, 2 reasons. The first reason is the one we've set out at paragraph 78, that this ground is premised on the idea that ground 1 is right, and we say ground 1 is not right. And there's a second reason, even if I'm wrong about that, it should nonetheless fail because the tribunal, first tier tribunal that is, expressly applied a lower threshold, said this was not a foreign criminal case, so they would apply a lower threshold. So even if my learned friend was right on ground 5 about lower threshold, well, that's what the tribunal did. And ground 6 is really a sort of summary of the earlier grounds, and again, I think I've dealt with that by going through the first tier tribunal's decision in some detail to explain how all the relevant factors were taken into account.
Thank you very much, Mr. Dunlop. Yes, Mr. Drummond.
I want in this reply just to concentrate on the concept of public interest and how,
Yes,
that fits into the framework that we're examining, and that involves looking at what was decided by Lord Justice Ryder in Akinyemi. But can I start by saying that I completely agree with the thinking that led to the question by Lord Justice Snowden of whether it is legitimate in these circumstances, in a situation where deportation is not an available option at the time of the commission of the offence or the conviction, because the individual is a British national. Not legitimate for the Secretary of State to use the fact that British nationality has been renounced in order to remove. Simply isn't a sensible way in which it can be said to be in the public interest to take advantage, I don't mean to be pejorative, but to use the fact that we have ended up in a circumstance where deportation is a matter of law available, but which is not actually a situation that was present at the time of the commission of the offence or the conviction. So, and we will go to see, these are as short as I can, precisely what the reasoning of Lord Justice Ryder is in Akinyemi. I do say that reasoning is binding on this court. It clearly distinguishes the Akinyemi and I would say our present situation from the Paradigm case, which is what is being dealt with in HA Iran and the other authorities.
Just before we go back to that,
Yes.
can I just pick up a point which embarrassingly I hadn't picked up earlier but came up in the course of Mr. Dunlop's submissions? I had certainly read you initially as saying that the key date for the application of the test in section 32 and 117C is date of conviction. But it is true, as he picked up, that in your answer to my lord, you appeared to be saying, alternatively, date of the offence, and that's in the formula you've just mentioned, date of the offence just now. What is your position on that?
The position is date of conviction, but my fundamental position is that there's no need to distinguish between them.
Right.
Well, on the facts of this case, there plainly is not. But nevertheless, as a matter of statutory construction, when I put to you the hypothesis of a case where citizenship changed between offence and conviction, you said the relevant date would be offence.
Yes. Well, the plainly is a principled reason which is related to the argument on dubious penalisation, for it to be the date of the offence. You commit the offence. What is predictable at that stage is that you will be subject to a sentencing regime in the full sense of that word in the criminal courts. And you wouldn't in the criminal courts be able to, on ordinary principles, unless the statute explicitly authorised retrospective effect, you wouldn't be able to impose a penalty that could not be imposed at the time of the commission of the offence. Now, by parity of reasoning, you commit the offence on date X. You know, obviously no one actually thinks like this, but the basis on which the rule is drawn up, you know that certain consequences, including deportation, can or can't follow. In these circumstances, it can't follow because it's not a penalty available on the facts as at the date of the offence.
No, well, I see how you. I see why you say that. But I'm sorry, I took you out of your course. You were about to take us back in Yemi.
Well, not
unless you want to say more about that. Yeah.
Can I just make a series of short related submissions?
Yes.
First of all, I don't accept my learned friend's use of the fact that my client voluntarily agreed to go to Pakistan. The simple fact is that we are where we are. He has not gone to Pakistan. He is in the United Kingdom, actually on remand at the moment. The Secretary of State wishes to remove him to Pakistan. In order to do so, he or she has to point to the appropriate, properly defined public interest in removing him to Pakistan. And that must take account of the perspective that lay behind Lord Justice Snowden's question. Is it legitimate to bring the full public interest considerations that would flow in the case of uncomplicated foreign criminal, if I can put it like that, from a murder conviction, to someone who was not a foreign criminal at the moment of the commission of the offence or of the conviction, if that is the date that the court decides is a relevant date? And we give the answer to that, no. You cannot simply read the public interest account across into those circumstances. Have to fix the public interest analysis in relation not just to the offence, but to the reason why the deportation power is available, which is that my client gave up his British nationality for the motivation which is set out in the first tier tribunal decision and repeated in our skeleton. The issue is, what public interest in removal does that set of circumstances give rise to? The answer that the FTT gave to that is the first sentence of paragraph. The first sentence of paragraph 26 at page 163. The FTT regarded it as axiomatic that there was a high public interest in deportation. That's what the first sentence says. That's formulated without reference to the particular circumstances that we are dealing with, namely offence committed when a British citizen, conviction occurring when a British citizen, and a later renunciation for motivation unconnected with the offence, perfectly understandable motivation to do with a desire to go to Pakistan, which turns out to be falsified by events as they have taken place. That ability to go to Pakistan didn't mature. Now, what, my rhetorical question I've asked several times and I'll stop, is the public interest in deportation in those particular circumstances? Now, one possibility that we have canvassed in argument is that all of this is dealt with through 117C6, as being a very compelling circumstance. But I repeat the submission I made this morning, that's a very awkward way of doing it. If I can just ask your lordships to imagine 117, the structure of 117, go back to 117, which is in any of the authorities manual. Working through 117C on the basis that it does apply, what the application of 117C would require is an evaluation of whether exceptions 1 or 2 applies. That includes lawful residence in the United Kingdom for most of C's life, C117C4 A.
I'm sorry to interrupt you, but if one's working systematically through 117C, the starting point is subsection 1, which says the deportation of foreign criminals is in the public interest. Yes. So that's the parliamentary determination of that. Secondly, subsection 2, the more serious the offence committed by the foreign criminal, the greater is the public interest in deportation of the criminal. So those are the two starting points that Parliament gives us.
Yes, but they must be read on the perspective that we gained from Akinyemi number 2, which is, true it is, that we have those statements in the statute, but there will be circumstances of which these cases are, both this case and Akinyemi number 2 are examples where the public interest falls to be applied on the basis of a very much lower scale of approach than is evident on the basis of the FTT decision. That is precisely what the reasoning of
is that right? Because if you look then at subsection 4, exception 1 applies where A, C has been lawfully resident in the UK for most of C's life. Yes. So the whole structure of this is presupposing that the public interest considerations identified in subsections 1 and 2 will apply even where C has been lawfully resident in the UK for most of C's life. And additional criteria have to be identified by C to establish exception 1.
But even if he is seeking to establish exception 1, he may be in the 117C6 territory of very compelling circumstances, which is the point I'm trying to explore at the moment. If you imagine a whole life case, probably has slightly the wrong connotation in this context, but someone who's been in the UK the whole of their life, was or could have been a UK national. I think Mr. Dunlop accepts that that those factors can found a very compelling reason over and above exceptions 1 or 2 in order for 117C to work at all. Otherwise we are stuck with a forced deportation in circumstances where the Court of Appeal has said twice shouldn't occur.
Well, to be fair, I mean, did not say it shouldn't occur. It said it had to be looked at very, very carefully. It was an unusual situation.
Yes.
And we now told in the end, Tribunal, correctly directing itself, has decided he shouldn't have been deported.
Yes.
That's all the Court of Appeal said.
Yes, well, I agree with that, obviously. But that necessarily means that it is open to Mr. Akinyemi or to my client to point to very compelling circumstances over and above the exceptions.
To be sure, and it's open, therefore, to both Mr. Akinyemi and to your client to say, hold on a minute, I was born in the UK, I was a UK citizen, and that must be taken into account. But why does it go any further than that?
Well, it goes further than that. The point I'm making at the moment is simply that doing this through the machine, describing that situation as a very compelling circumstance, is what you have to do in order to make 117C.
But why is it so terrible to call it a very compelling circumstance? We mustn't get absolutely hard. These are just adjectives. The message of NA and all the cases is that ultimately you do a proportionality assessment, and what the statement about very compelling circumstances is doing is simply saying that where you've committed a serious criminal offence, you'll need to show something very special. And you, in the kind of case where Mr. Dunlop sensibly admitted it would have been possible for example, where he'd been misled into giving up his...
It's that caveat which actually led to this submission, because your lordship put to Mr. Dunlop the proposition that you can't apply exception 1 on the basis that if you fail completely, say, the significant obstacles to integration, it's not open to you when you get to C6, very compelling circumstances over and above, to say that there are compelling circumstances over and above when you completely failed one of the limbs of 117C.
Well, that's not right as a matter of law, is it?
No, that's the submission I'm making. He then retreated. He drew back into an example which was the deception example. You're giving up your nationality. You're being induced by a misrepresentation of the Home Office. My submission is much simpler than that. That either you don't do it through 117C at all, which is my ground 1.1. But if I'm failing on that, then this court should make it plain in judgment that very compelling circumstances doesn't require a near miss or anything like that. It applies in the way in which Lord Justice Ryder applied it in Akinyemi number 2. That's the target of the submission. Akinyemi number 2 is a carefully thought out judgment with respect, making a deliberate point about the class of individuals that it's applying to, who are those who are not the paradigm criminal offenders. And coming up in favour of a substantially reduced public interest in deportation in those circumstances, in the context of reading 117C, that the statutory material that what Justice Ryder is dealing with is all of this statutory material. My submission is that the court should be very slow to reduce very compelling circumstances, sort of something like renunciation induced by misrepresentation. It can just be Akinyemi-style facts. Whole life in the UK, no connection with the state to which you're going, and indeed, in my case, British citizenship. I know there are things to be said for and against that analysis on my facts, but that's the bottom line. That is a very compelling circumstance. So it is possible to make out very compelling circumstances on that analysis, even if you've completely failed one of the limbs within exception 1. That's my message.
Yeah, I see how you put it.
And I think the next submission I wanted to make, but I think I've made it already, is that the voluntary enunciation of citizenship doesn't carry the weight that Mr. Dunlop puts on it. Axiomatically, because of where we are, my client didn't go to Pakistan. And the reasoning of the FTT and Secretary of State has to point to the public interest in deportation that arises in those circumstances, not in the paradigm foreign criminal case.
Could it be said that a foreign person thinking of committing an offence in this country would look at the situation of your client if he were deported and say, well, crikey, if they're going to deport somebody who is a foreign national in those circumstances, notwithstanding that he was a British citizen, I absolutely recognise that if I, a foreign citizen, commit an offence, I'll be deported, so I better not do it. In other words, is it not enhancing the paragraph 15b requirement in OH at paragraph 8 that we looked at? In other words,
I think that's my next and possibly last submission is to go. I'm happy to deal with that run of paragraphs, which I think is the way to do it. I mean, the answer to your Lordship's question is I would regard that as illegitimate. It is akin to using a power to give effect to a public interest which doesn't in truth arise in the ordinary class of case with which you're dealing. I mean, which if we go to OH, go get the subject matter. Sorry, I'm trying to time. Tab 8.
Yep.
First of all, the passage in Law and Justice Judges judgment set out 106 in fact in paragraph 14. And I think Lord Justice Snowden may have had in mind the first 4 lines. In my judgment, whether expressly referred to in any decision letter or not, borders issues of social cohesion and public confidence in the administration of the system by which control is exercised over non-British citizens who enter and remain in the kingdom are engaged. Well, that's obviously correct. My submission is that as Lord Justice Judge is not there dealing with the Akinyemi or my client's situation, someone born in the UK, and indeed a British national at the time of the offence. It's very difficult to understand why it could be said that public confidence in the administration of justice will be enhanced by the operation of a power which is only fortuitously available on the facts of a particular case. It's not logically related. to the gravity of the offence or public revulsion in the sense in which Lord Wilson used that expression in paragraph 15 of the judgment.
Well, only fortuitously available. It is available because they have given up British citizenship. Imagine a case in which someone with dual citizenship who has committed a serious offence as a political gesture says, I don't want to belong to this country anymore. I think I don't approve of its values or whatever, and I renounce my British citizenship. I'm not sure. I think the public might well think there was something wrong in the system which said, well, now the only reason, before you couldn't send him home or to the other country of which he belongs because he was a British citizen. But now that he has voluntarily given up his British citizenship, I would expect you to be able to do that, having committed this very serious crime in the past, whatever it was. So to say it's only fortuitous because that wasn't the case at the time that he committed the crime or committed the offence, I don't think goes to the heart of the thinking that lies behind the exercise of this power.
Well, the thinking that lies behind the exercise of the power is evidenced by this line of authority, as far as we can see. We've seen all the other explanatory material and so on. It's evidenced by Packing number 2 itself, and by the exchanges between Lord Carr and Lord Wilson in Hesham-Ali. It's not evidenced anywhere else. And so the proposition that it's in the public interest to deport someone because the public would, on this sort of factual hypothesis, expect it to happen, is very precisely what both Lord Wilson and Lord Carr are saying is not an appropriate approach in Hesham-Ali. It's at the outer reaches of what of the weight that you should be given to public opinion. The simple question here is, there's an offence committed at a time when my client is not liable to deportation. He then renounces his citizenship and doesn't, but in the end can't get to Pakistan. What is the public interest in deporting him? The answer that I'm getting back from the court, it's in the public confidence considerations in...
Well, also the deterrence considerations, which what my lord put to you. My learned lord put to you.
Yes, but it's all a big stretch away. I mean, even deterrence is not an easy argument when the vast bulk of British citizens who commit murder are simply not liable to deportation at all because of the very...
That proves too much, which is certainly blessed by authority not be removed when they commit these offences.
Yeah.
Anyway, there we are.
Yeah. Well, can I just make the submission, the remaining submission, while we have got OH Serbia open?
Yes.
One goes down from Lord Justice Judge's dicta, which we see in paragraph 14. Paragraph 50 records Lord Wilson as saying, the risk of offending is one facet of the public interest, but in the case of very serious crimes, not the most important facet. Another important facet is the need to deter foreign nationals from committing serious crime by leading them to understand that whatever the circumstances, one consequence of this may well be deportation. My submission is that there he is dealing with people who are aware that they have a precarious immigration status. They are liable to be removed. He certainly, I mean, he isn't expressly dealing with a situation in which the unusual exercise of the power on the facts of this case might deter somebody who is in a more orthodox way vulnerable to deportation. And a very similar point arises in 15C. They're all aimed at the paradigm class that Lord Justice Ryder discusses in
Yes. Yes.
Now, the only other point is to repeat the submissions I made notionally, if you all should wrote them down, with references to the earlier paragraphs, earlier than I think my learner friend took you to 52 in academic language, 52 and 53, I think. But the earlier paragraphs make it crystal clear what Lord Justice Ryder.
Well, I understand that. That's where you're getting this language of the non-paradigm cases
Exactly.
from. No, I understand that entirely. Yeah.
Those are the submissions. I'm sorry to have taken
No, well, we're very grateful to both counsel for succinct and cogent submissions. We will reserve our decision. Draft judgments will be circulated in due course so that the parties can agree the terms of any consequential orders, or if they can't agree them, supply brief written submissions so that we can make a decision at the time of hand down, and also, of course, draw our attention to any typographical or other minor factual errors. Thank you very much.